Hello everybody, it's Makea Turner here with Realty One Group here in Las Vegas. I have a special treat for everyone. I have the opportunity to interview Tiffany Ballinger. She's an attorney here in Las Vegas with Black & LaBello. So Tiffany, why don't you go ahead and let us all know what you specialize in and how you can assist some homeowners out there who may be facing foreclosure.
Wonderful, thank you very much. Well, I practice in the areas of estate planning, asset protection, and most of all right now, real estate. Most of my clients are homeowners who are looking to short sell, possibly, or do a strategic foreclosure on their homes. They understand that in Clark County, Nevada in 2010, we have one of the highest rates of properties that have negative equity or that are underwater. And under current projections, those prices just aren't coming back for the next 15 to 20 years. So they're aware that they need to make some decisions now so that they can plan the rest of their financial future.
So what are some options that a homeowner has when they're facing foreclosure?
Well, once you're in a foreclosure situation, it's when the bank has recorded a notice of default or a notice of breach on the property. And that typically will occur after around 90 days of missed payments. At that point, you have some options still. The banks are slow to act right now. Of course, they're changing their policies every day, but there's Nevada foreclosure mediation, there's exploring short sale, there's exploring loan modification options or other workouts with the bank. So it's very important that just because you've had a foreclosure begin, that you're not ignoring the other options that are available.
Okay, can you briefly explain to us what a strategic default is and someone who may have other assets, how that may be able to assist them?
That's a great question. A strategic default gets thrown around a lot nowadays. What we're seeing is that in this wave, currently homeowners have their properties. They could possibly afford to keep that property. They can afford the monthly payments. However, they realize that they're throwing all of their money into this investment that's not, first of all, it's underwater right now, and second of all, it's probably not going to see a positive equity position for many years. So they are sitting down with their financial planners, their CPAs, their attorneys, their agents, and discussing other options to liquidate that property, either through foreclosure, through short sale, or something like that.
Okay, can you briefly describe what the consequences of foreclosure versus a short sale and how that can affect a homeowner?
Okay, so when a foreclosure occurs and the property is sold at the trustee's sale, which means the property is no longer owned by the homeowner, it either sells to a third party at auction or it reverts back to the bank in many circumstances. A timeline kicks in at that point. And after that sale date, a bank has 6 months to pursue that homeowner for the difference between what they owe and what they got at the sale. That's that statute of limitations, and that is on the foreclosing lender. So if you have a first, second, and third, it's whoever initiated the foreclosure itself. Now, any subordinate liens or obligations, they have a statute of limitations of 6 years after the foreclosure. So that's something to be aware of. Just because your property was foreclosed on and the first didn't sue you within that 6 months, you need to be aware that a second lien may have 6 years. They have that right. After a short sale, if you do not get a valid deficiency release in writing from the bank, which means the bank is agreeing to the short sale, number one, so they're agreeing to release the lien on the property, they also have to agree to release you from that underlying obligation on the promissory note. So there's two different obligations that you're signing. So just because they agree to a short sale doesn't mean they're letting you off the hook for that deficiency.
Wow. So I know a lot of homeowners, they think that when they see that release of lien that they're getting let off the hook. So I'm glad that you did, briefly discuss that with us today. My next question for you is, what is the Nevada Mediation Program, and why is this important to a homeowner who's facing foreclosure?
The Nevada Foreclosure Mediation Program was set up by the Supreme Court of Nevada to give homeowners, banks, and a third-party mediator an opportunity to get together and try to find an alternative workout on the problem. Homeowner, it's very important. Number one, it's only for your primary residence, owner-occupied primary residence, and on whatever the foreclosing lender is. So if you have a second, the mediation is not going to cover it. If you have an investment property, you're not going to be eligible for the mediation program. Now, what we've seen, it's also important, there's a strict deadline. That notice of breach or notice of default, once that is filed, you have a 30-day window to elect to participate in the mediation program. And if you let that pass, there's no going back. So it's important that homeowners realize if they get this notice of default, they need to act and they need to think about participating in mediation.
Okay, what advice would you have for a homeowner who, may have gotten that notice of default, but then their banks are telling them, we can maybe do a loan modification? Would you still tell them to elect?
Absolutely, absolutely.
Okay.
Mediation is an important tool for us. We're not seeing a lot of short sales approved through mediation, honestly, or a lot of great loan modifications approved through mediation, even though that's what it was really set up for. But what we are seeing is that it gives the homeowner more time. Because a bank cannot foreclose on a property once a client has elected to participate in mediation and before that mediation has occurred. So it stops. It pauses, I guess, the foreclosure. So the client can come in and they can look at short sale options or loan modification options, and it gives them more time to explore their other areas.
Would you recommend that a homeowner who's going to do the mediation program, that they have an attorney represent them?
I would always recommend that they at least seek legal counsel prior to the mediation. It's a wonderful idea to have an attorney present with you if you have the means to do so. There's also some wonderful nonprofit organizations and legal aid that can assist if you don't have that opportunity. But the most important thing to remember is that the lender, the bank, they have their attorney there. So if you're going without an attorney, you kind of are at a disadvantage. Now, another thing to note is that the mediator is a neutral party. They do not have any binding authority. They can't force you into a decision. They're not a judge. So it is an opportunity for everyone to sit down and look at the options, but you don't have to make a decision right there and then and agree to anything that any party is saying necessarily.
Is short selling your home a bad decision? I know a lot of homeowners, they kind of would rather walk away than even looking at the short sale option.
It depends. Every client's different, but in most circumstances, I look at short sale as plan A. The reason being is, number one, you have more bargaining power when you're doing a short sale rather than allowing the property to go to foreclosure. You can attempt to get a workout on the first and get that deficiency judgment on the first and the second and any other liens. You're also putting yourself in a good circumstance because you are trying to mitigate the bank's losses by attempting to do the short sale. Remember, on average, the bank gets 30% more from a short sale than they do from a foreclosure. So in that event, you're doing everything and you're acting in good faith as a homeowner in saying, hey, I can't keep this property anymore, but I'm going to try to do the best thing. Try to short sale, and then if that doesn't work out, we look at plan B, C, whatever the case may be.
Tiffany, should the homeowner meet with an attorney prior to listing their home as a short sale? And if so, why should they do that?
Of course, as an attorney, I'm going to say absolutely. But it is very important that a homeowner seek legal counsel before deciding what to do. There are statute of limitations, there's possible liabilities and rights that they may not have knowledge of. There's also tax consequences. So when my clients come in to meet with me, I also advise that they seek the advice of a CPA or an accountant prior to doing a sale. It's a really big deal. And just walking away from a property and, kind of putting your head in the sand or doing a short sale without advice can open yourself up to a lot of risk that you should at least be aware of prior to doing so.
Yeah, That's definitely some good advice. Like I tell everyone, align yourself with a team of professionals, not just a real estate agent. You need a real estate attorney, CPA. I mean, it's definitely a good thing to align yourself with qualified professionals.
The market isn't what it used to be. If we were sitting here in 2006, you don't necessarily need to see an attorney before you close on a sale. And most traditional sales are pretty straightforward, but it's a completely different game out there, and people really need to be aware of that.